All right, good evening, everybody. I'm going to start the session. I know there are quite a few people that will still be joining us, but let them join us then a bit late. They will pick up what the session is about. The session, as you heard, is being recorded, and we will make it available on social media tomorrow. Just to explain what today's tutorial is about, it is really the point of today's meeting is just to orientate everybody as to how the learning process is going to unfold over the next few weeks. So we're not going to be getting into content this evening. We're not going to be going into the actual legal principles or any of the practical advice that we give in respect of the actual content. But what we do want to do is start orientating people about how the process works and how the different learning tools work that you'll be exposed to. You'll become very familiar with them over the next few days and weeks, but it's good to orientate people from the outset. There is in the group today, we've made it available to people who are participating in the free training or in the advanced expert witness training. Just a couple of points to make on that. The free training, and I'll take you through in more detail the differences between the free training and the advanced training. The advanced training, in summary, will just give a lot more content, and will also give a certification and CPD points, which will not be available for the free training. But other than that, the systems do run quite similarly, and we'll have a look at how they work on the website and how they will be presented. For the advanced expert witness training, on the 24th of January will be the workshop. And we will see in a moment when you go through the learning outcomes from this particular course, you'll see that the workshop is heavily focused on teaching actual professional skills. So as opposed to, it's more foundational theoretical basis. The theory and the legal principles themselves, for those that have done the intermediate expert witness training, will be familiar with the expert witness, the legal principles applying to expert witness evidence, which we dealt with in detail in the intermediate training. The advanced training takes those legal principles which we dealt with in detail in the intermediate training and then applies it to a practical situation, and it's a much more skills-based outcome. It is a bit of a journey in the sense that there is content to be covered, but at the end of the day, what we focused on much more with the advanced training is skills outcomes. Hence, it's advanced. So we're superimposing the practical skills that you need in your practice on a daily basis and putting that on the intermediate level or the legal principles level. If you haven't done the intermediate expert witness training course, it is not a prerequisite to do the advanced course. In other words, you don't have to have done the intermediate expert witness training course in order to do the advanced course. However, it is recommended that you then go back and do the intermediate expert witness training course, because the advanced skills will only really properly, and you'll see why as we do the course, but they'll only really properly be of benefit to you when you understand the intermediate, in other words, the legal principles underlying those skills. So by doing the advanced course, you're going to get skills and it will be useful. But if you go back and do the intermediate training course, then those skills will take on a much wider range of meaning and a deeper meaning as well. So it's recommended that you go back and do the intermediate training course if you haven't done so yet, but you can do them either way around. The other point to make is for the free training, it will be somewhat skills-based, but basically typically what we do on the free training is we give a certain amount, there are 2 topics per lesson. We'll give 2 topics which will give it a basic orientation and give you a basic understanding of the topic. But also, if you're doing the free training course, then it allows you to interact with the software, to have a look at the product itself, to have a look at the training experience and see if it's a good fit for you, and just have that kind of immersive experience and then to make a decision. The registration for the advanced expert witness training is open until the 24th of January. So although we're making the content available now, the course has not formally started. And I'll explain that to everybody in a minute. But really what it is that the training will happen on the 24th and the 31st of January. So that's the workshop, and then the mock trial on the 31st. And the way it will work is on the 24th, we will take the groundwork that we do now over the next few weeks. We'll lay a foundation over the next few weeks to give you the mental equipment to be able to then on the 24th maximize what you've got. So we don't have to on the 24th then go and teach you principles. We want on the 24th on the workshop to really be focusing on the practical implementation of those skills. So it's a bit of a different focus. And then on the 31st, which is the mock trial, we're going to take those practical skills, which you will have then learned over the next few weeks on the online content, which will then be bedded in on the 24th. And then we will give you examples, actual, realistic court examples of how these things play out in the open court, and also a little bit before, so in your preparation, and a little bit on the appeal side. But we will give most of our focus will be on the actual courtroom experience and how to prepare for that courtroom experience and how to manage it in the experience. So very skills-based, practical-based, as I say. So that is a general overview. Why we're doing this preparation then over the next few weeks is because there is a lot of content around these subjects. And when you work through the material, you'll see in the very first lesson, we deal with the importance of case law, and I'll get to that in a moment to unpack it more carefully, but I just want to make this point for now, that it is very important that the principles applying to preparing and presenting expert evidence in court, which are required by the judges, are understood by experts. You must know what is expected of you, because the judges expect you to know, and they are becoming more and more insistent about that. Those of you that have done the intermediate training course will know what I'm talking about. In some of the classic cases where there's been Twine versus Naidu is probably the classic case, where the judges have criticized expert witnesses for not understanding what the law requires them to do. So that it's very important to understand what those principles are and how to apply them in practice. And that really is what that's the way that the South African Medico-Legal Reports looks at all of our content. We tie it very closely in with what the judges want. We do not just go off and think, well, we think this would be a good idea or that would be a good idea, or listen even to an experienced expert. We look at what the courts require, and it's quite an intellectually disciplined approach which we take. We tie our materials, all our materials are tied in very closely to what judges actually say and what they actually want and what actually happens in the courtroom. So that's not to say that experience doesn't play a role. We listen to experienced experts, to experienced advocates, we'll interact with judges, we'll interact with academics. But at the end of the day, the position that we come from is that you need to know what happens in court, and that is really where we position ourselves, as we will let you know what is required of you by the courts. That's the South African Medico-Legal Reports approach. So a very principle-based approach. All right, now just having given that background, I just would like to take you through the learning outcomes from the course. The course is very much based on focusing on learning outcomes, and we've set out the key learning outcomes and you will see from the learning outcomes that it's extensive. So the outcomes that we're looking for from this course are extensive and cannot simply be taught on a Saturday 6-hour session and then on another mock trial session 6 hours and 6 hours. We will get a lot done in those 6 hours, but the only way that we're really going to be able to ground you guys and give you a proper, thorough understanding and start feeling that you're confidently in charge of this material is to allow you additional time to explore these concepts, and even after the courses, the 2 training days are completed, to have a resource where you can go back and work through this material at your leisure. And we'll show you there's a particular methodology that we use where you can go back and have it at your fingertips and refresh your memory and then work your way through it. Incidentally, while we're on that point, we often get asked about CPD points. We always have CPD points with any of our training, and that will be the case with this point as well, with this course as well. That's one component, and that's a very practical, realistic benefit. But there's also the benefit which we think is the real benefit, which is the skills. And let's just go through that. So the key learning outcome, session 1, general principles of presenting expert witness evidence in high court civil trials. So This is session 1 will give you the sort of general principles, 90 minutes that we're going to cover on the Saturday on the 24th. Okay. So the first key learning outcome, understand the importance and effect of case law on the legal requirements of presenting expert evidence. And I'm going to take you, when we look at the learning management model, in other words, the website-based model that you guys will be given access to and the learning system on the website, you'll see that the importance of the case law. It is very important that you understand the fundamentals of case law, because what the judges say should happen actually becomes the law, as much as it's almost like an act of parliament. So it's very important to understand the case law. And then there's a particular aspect to understanding the case law, which is becoming very important for expert witnesses, lawyers, everybody involved in this field to understand, and that's the use of AI and how AI can appropriately be utilized in respect of case law. Now, I just want to tell you, we do have a webinar coming up on expert witnesses and AI and the use of AI. That webinar is going to be a bit broader in its scope. So it's not only going to focus on your court work. The AI that we deal with in this course will be primarily, we'll have a look at it in respect of how experts can now start accessing judgments, because AI will give a summary of a judgment. And so it therefore, up to now, it's been very difficult for experts to access judgments. But with the use of AI, you're starting to get summary of judgments. And how should that be used? What is the appropriate way to access that? Should it be accessed at all? Should it not be accessed? We look at all of that. So, and to teach you the importance and effect of case law, including the use of AI. Then I'm not sure whether there's a duplication in the next block. I apologize for that. I'll sort that out on the website later. But anyway, to understand the importance and effect of case law on the legal requirements of presenting expert evidence, it's very important that the effect of case law is understood. As I've just said, when a judge makes a pronouncement, it becomes binding. It actually becomes the law in a sense. Not in a sense it does. It's a source of law, and particularly with regards expert witnesses and lawyers using expert witnesses, it is very important that you understand the principles governing the preparation and presentation of evidence, because if you don't, it's no excuse not to understand that. The question is, where do you access this? Because as I've just said, it's difficult for experts to access the case law and to know what the judges are saying. Well, that's what the South African Medico-Legal Reports does. It keeps a very close eye on the judgments. It looks at the legal principles emerging. There is, as I've said, an increasing need for experts to understand what their requirements are. The South African Medico-Legal Reports monitors the judgments. We work very closely with what the courts are saying, and we also work very closely with very experienced experts, very experienced legal practitioners, and we will then put together that practical, skills-based approach that I referred to earlier. Then the next point, be able to formulate an argument defending their qualification to express such an opinion if challenged by using relevant legal principles. So you must be able to, when you start off engaging with your material, so you typically be an instruction from an instructing attorney, being able to formulate an argument defending your qualifications. So what this is do you qualify as an expert? You'll remember, those that did the intermediate training course will remember that the question of whether one qualifies as an expert is an important issue right at the beginning of the process. When you get your instruction, you should be applying your mind to whether, in fact, you qualify as an expert. Now, in order to do that, you need to understand what exactly is requested, what exactly an expert is, and then you will know whether you qualify or not. You'll have a much better informed idea. So that is then important. Then you need to, and then also what we will do is we'll build into, and this comes down to the skills-based approach, we will build into your reports how you protect yourself against that line of attack. Now, again, those that did the intermediate expert witness training will remember that there were 5 lines of attack which advocates are taught when they are pupils, when they're still not even properly qualified advocates. They're taught 5 lines of attack on expert witnesses, and they're trained on those lines of attack. One of the lines of attack is to attack the qualifications of the expert. How do you start protecting yourself, bulletproof yourself right from the beginning to withstand that line of attack? So we will have a look at that. Then the next point, which is important, is that you'll learn how to demonstrate an understanding of the expert witness's implied duties to the lay client and be able to assess the conduct of an expert witness in respect of whether such duty has been complied with. Okay, so now what's important here is that you as an expert, the courts say that you as an expert have a duty to your lay client. So this duty which is distinct from your duty to your attorney and is distinct from your duty to the court. So in fact, a number of areas where you have duties when you are involving yourself in a trial as an expert witness. The area of duty that we explore in that particular skill is an understanding of the implied duties to the lay client. And there's a reason for that. And the reason is that the duties towards the lay client line up with your duties towards the court. We'll deal with it in that topic, but you'll see when you get into the material that those two concepts of the duty to the lay client, the duty to the court should be in alignment. And the courts are very clear on that. There's no distinction between your duty to the court and the duty to the lay client. Now, when you do in the intermediate expert witness training course, that we went in detail into the principles governing expert witnesses as promulgated by the courts and what required by the courts. Okay. So what that means is that we don't look at those concepts in detail in this course. That's dealt with in the intermediate course, but we look now at the application of those principles and how it extends beyond merely a duty to the court, but a duty to your lay client. And then also, just the last point to the duty to the lay client, we also have a look at what are the implications of not complying with that duty? What is the risk? And what is the potential negative outcome? It is potentially serious, I must warn you. And we haven't really seen that yet the courts move into this area, but there have been some ominous sounds from the courts if expert witnesses do not comply with their duties and do not have a proper understanding of what their duties are towards the lay client, i.e. their duties towards the courts, be aware of the potential implications. So that's the next one. And then the next point is demonstrates an understanding of the proper development of a logically reasoned argument as required by judges through case law. Now, this is very important. And again, intermediate expert witness training course, we dealt with Michael versus Linksfield Park Clinic. There was also a recent video by Carlos de Silva SC where he took us through how the courts assess expert evidence, particularly where there's a conflict between experts. And how does the court approach that? And those who have done the course will remember that it is the assessment of the logically reasoned argument that the courts are primarily concerned with. That is how they will assess how good or bad a report, or more accurately, how acceptable a report is to the court. And if there is a conflict between two experts, the better logically reasoned report and that central argument running through the report is what matters. Now, in this case, there will be an understanding in this course. We take that principle and then we apply it, and we will actually have a look at the courts have given guidance on what it is that you need to put in your report to make it a compellingly, logically reasoned argument, and therefore a good, strong report and good, strong evidence later. Okay, then you will learn how to identify errors in the process of logical reasoning due to it being irrational. Now, that flows from the point I've just made. As a follow-on from what the judges have said about a logically reasoned argument, you are then also going to be able to assess and look out for irrationality in a logically reasoned argument. Now, why is this particularly important? Firstly, to assess your own reports and your own reasoning process, obviously. But remember, if you're getting into a situation where there's potential conflict with another expert, very, very useful to understand what the courts say about identifying irrationality and where logically, an allegedly logically reasoned argument falls down, so that you can then subject your opposite numbers, report, and evidence to that scrutiny. Very useful to understand what the courts are saying, and gives you some nice guidelines as to how to approach that sort of reasoning process. Then the next point is dealing with establishing facts in evidence. There are principles which the courts have developed, And we will have a look at those principles and have a look at the practical implication of those principles. So when you want to establish facts in evidence, there are various different types and categories of facts. How do you handle those categories of facts? That will be dealt with. Then you will be able to properly establish the factual foundation of the expert's opinion in accordance with the relevant legal principles. So that flows from the previous point. You will then learn how to actually manage those facts, how to marshal those facts, and how to implement those facts. Very, very important. And then utilize the principles relating to prospects of an event occurring being expressed as a balance of probabilities. This question comes up quite a lot, but how do we deal with balance of probabilities as opposed to scientific certainty? Again, the intermediate expert witness course participants will know that there's law on this, that the courts have in fact pronounced on it. But we will then have a look at the skills involved in utilizing that balance of probabilities approach when dealing with expert evidence, either in your report or in your presentation. Okay, then we've got session 2. Now I'm just going through how the workshop will work, but this is, as should be apparent to you from now, all of these learning outcomes will then apply to the work that we do between now and the 24th, and indeed all the way from the 24th to the 31st. So I would say from now all the way through the month of January, all of these learning outcomes will be enjoying quite a lot of attention. You'll get a lot of support and guidance over the next few weeks to internalize this kind of information so that you can use it properly on a practical daily level. Okay, let's have a look at these. Firstly, so now we're going to have a look at some specific principles of presenting expert witness evidence in the High Court civil trials. Remember, our focus on High Court civil trials, but a lot of these principles will apply whether you're doing criminal work, magistrates court work, whether you're in a mediation, any of those areas. These principles are all relevant and can be adapted. Obviously, you've got to be mindful. So there are certain things where, for instance, Rule 36.9 won't apply directly to mediations, although indirectly it would, but it wouldn't apply in the magistrates court, but the principles would still apply. All right, then we'll have a look at in the intermediate expert witness training course, we dealt with assumptions and inferences. Here we will look at some practical examples of assumptions and inferences. We approached the material in the intermediate course as being that people were at least had a working knowledge of the difference between assumption and inference. Here we will really spell that out and really dig deep into that and have a look at some of the real practical, what's the difference between the two and how should that properly be marshaled. Then properly develop a legally valid inference from the established facts. How do you do that? What is an inference? Why is it so important? And then it is actually a very, very important aspect of all the work that the court does. It's a very important aspect of what judges do. Judges need to draw inferences from established facts. It is important to understand that firstly, that is what judges do, that they are very familiar with the principles governing how they do that. And once you know that and you're aware of that, then you can start using that to your advantage, and you can start making progress in how you then draw inferences from established facts. Okay, then next is to construct a validly drafted set of assumptions to be included in an expert report. Now, we've dealt with the inferences. We're now going more into onto the assumptions. Again, from the intermediate course, remember the assumptions are important. There are different categories of assumptions, but how should those assumptions be dealt with in drafting the expert report in particular? So there we will have a look specifically at the expert report. And then the next one is developing an opinion which is provisional or qualified. So very often comes up in practice. You'll all know that you have to give a provisional report. It's something that I get asked about surprisingly often is addendums or supplementary reports. My feeling is because that it sort of is more or less the same turf as giving a provisional or qualified report. It's kind of a similar type of territory. But it's important to understand how to give a provisional or qualified report. And I think I might even just expand that a little bit, although it's not formally on the learning outcomes. I think I may, because the question is coming up a lot, just also include some discussion on addendums and supplementary reports. The next learning outcome is to develop an appropriate and persuasive response to facts which could detract from the expert's opinion. So the principle there is don't just put your head in, don't be an ostrich, don't put your head in the sand. Those facts which could detract from your opinion have to be dealt with. It's in fact a key skill is to be able to deal with aspects of your opponent expert, if you like, of what he or she is saying in attacking you. And how do you undermine that? How do you deal with it? And the first point is, well, deal with it. Don't avoid it, deal with it, but then there's certain ways that you can deal with it that make it effective. Then the next learning outcome is to construct an opinion based on the views of professional bodies. This is particularly relevant to medical malpractice type work, where it comes up commonly is the question of whether a particular practitioner's conduct was reasonable. And one of the important yardsticks for reasonableness is the test is what would the reasonable practitioner within that particular branch of the profession do in the circumstances of the case. Remember that test. And the courts will and do look to the views of professional bodies to give them guidance. Ultimately, the court retains the discretion whether to accept the views of the professional body or not. But I can tell you, in practice, the courts are very heavily guided by the views of professional bodies. Then analyze the issues in respect of factual causation. Factual causation can become very complex. It is very important to have a good working knowledge of the sine qua non rule and the but-for test in factual causation. You must internalize that. You must understand it properly. You must use it without even really having to think it through. We will go through that in the course material. Next is to develop an opinion in which reliance is placed on literature. This does come up a lot, especially in the more complicated, high-octane type disputes where you have reliance on literature. There's case law on that. What exactly do the courts expect you to do? How must you present it? What are the requirements? And what is also a good idea and an effective way to approach the presentation of literature? Competing scientific theories, that obviously comes where if you have a dispute between experts, competing scientific theories, and scientific in the broad sense of the word, competing theories as to how the matter should be approached by different experts will be dealt with. And then to formulate an opinion dealing with the nature and extent of injuries, a practical discussion of a topic which is in fact governed by the uniform rules of court and on which there has been a lot of discussion in the case law. So that needs to be known by experts. Very often don't know even the provisions of Rule 1810, which spells out what needs to be dealt with in the expert report. Okay, then session 3, principles dealing with the expert report. This now we look more at the expert report itself. And again, just to reiterate, our approach to the expert report writing is that we don't have a template that we insist you must use this structure. But what is important is to understand the principles that should be incorporated in your particular model or structure of an expert report. We do give a suggested format for an expert report if you are looking for a format. It's based very much on the English law and on the English system, and then it's been adapted to the South African system. But what is very important about the approach which the South African Medico-Legal Reports takes to commentary on expert reports is what we try to do is we try to automatically bomb-proof your reports. What I mean by that is that we try very hard to incorporate any of these legal principles into the recommendations and guidelines that we give you on writing expert reports so that you don't unknowingly miss something or put something in that you shouldn't put in. So we take the principles that the courts require in respect of expert report writing, and we will then blend those into our recommendations. So for instance, if you need to do a certain thing in your report and not do a different thing, we will then guide you and effectively summarize and incorporate the case law into the steps that we say that you should take when for writing an expert report. So we do not take like we're teaching grade 1 children how to do the alphabet or 2 + 2 is 2. We teach you the principles underlying report writing. You all know how to write reports. Some of you have been writing reports for longer than I've been practicing. you will have a tried and tested formula that works. However, very, very few experts, to be brutally honest, understand the principles that they are supposed to incorporate in that report. So we take the approach that we want to equip you with an understanding of those principles, and you go back to your report and make sure that you're complying with those principles. And then being able to identify the issues in a dispute, and those that have trained with me before know that I harp on about this. The issues are very important, that you understand the issues from inception all the way through to when you get in the witness box, because what it does is it frames your evidence. It gives you your grounding as to what it is that you're trying to persuade the court as to. Because if you remember, an expert makes an argument. Remember, a logically reasoned conclusion. We looked at that a few minutes ago. And if you are making an argument, why are you making an argument? And I can tell you, you're making an argument to persuade the court. You're there to help the court. You must be unbiased. You must be objective. But at the end of the day, you are wanting to persuade the court that your argument is correct and not somebody else's. Or even if there isn't anybody else's, often happens, that your argument is correct, full stop. So that is and identifying the issues is the first step in persuading the court, because then you know what you're supposed to be saying and what you're supposed to be persuading the court about. Okay. Then the next thing is conducting consultations and interviews. We will have a look at some practical skills around that. A very important and often overlooked aspect of dealing with evidence. So there's principles on that, and we will take you through that. Then the next one is to be able to implement the recommended format of an expert report or portions thereof in order to advance the expert witness's case theory through a process of logical reasoning. So here, what we're doing, this is now taking this really to a high level. So the case theory, in other words, what is your theory as to what the correct position is? That is your step one. Then you've got your process of logical reasoning, how that applies to that case theory, and then how that then integrates into the recommended format of an expert report. So again, where we take you through step by step how to deal with the facts, how to deal with inferences and assumptions, and there are quite a number of steps in that process, but it takes you through advancing your case theory and providing a coherently, logically reasoned report, which should be persuasive and should then win the day as far as your area of expertise is concerned. Next, construct an expert report in order to comply with the requirements of the High Court. Those are formal requirements, and we will have a look at certain of the formal requirements there. We can't go through everything. Unfortunately, that would be a much longer course. So what we often do is we will refer back to the intermediate expert witness training course and say that those principles must be incorporated. But we try to summarize succinctly and the key principles in a simple and user-friendly way. And then to effectively present the expert's opinion. I think I've given a background to that, but that is how do you actually present your opinion and what makes it compelling for the court. And then how to correctly and persuasively use appendixes, whatever you want to say, to the expert report. Okay, and then just to remind you, so that the formal training will occur on the 24th and 31st of January. The first day is dedicated to the workshop, which is applying the legal principles governing expert witness evidence and drafting expert reports, how you apply those principles, as I say, skills-based, and then the mock trial, which is applying the legal principles to the courtroom for 6 hours. So those are the learning outcomes, which we will have a look at over the next few weeks, and eventually we will then end up with those learning outcomes and how that then affects your practice in a very sort of practical skills-based sense. And then I just want to take you now to, well, how do you now access the material? So as of tomorrow, and you will get notification through social media as to this, we will make the course available to those who are registered, formally registered for the course. I know that there are a number of you, I don't know whether you're in the meeting today or not, you might watch this video later, who have wanted to register, but they haven't gone through the formal registration process. If you paid your invoice, you will automatically be formally registered. And if you see social media and you can't get access to the course material, please get hold of me, and I will make sure that you are properly onboarded so that you can access the material. The material will be available during the course of tomorrow, so that by Thursday morning you will have access to that material. and you can start working through it. And I just want to show you how to access it. This is the South African Medico-Legal Reports website. I'm not going to go into the other tabs at the moment. It's going to take you to courses and webinars, just from a time point of view. And you'll see that there are 3 courses available. The intermediate expert witness course, I'm not going to deal with now, but the free training, I just want to touch on that, and then the advanced expert witness training as well. And I'm going to start with the advanced expert witness training. So you will enroll, it will take you in, and then you will see there's the price, and here are there's the price. If you've paid, then you're enrolled. If you have any problem accessing this, please, we're rolling out this learner management software now. So if there are any technical glitches, please get a hold of us. We will sort it out for you. We are on the lookout for any problems. And you'll see here that once you've got access to the course, then you will get access to the content, and you'll then be able to go into the content, and you'll see that each topic has a lesson. So let's have a look at lesson 1. Using AI to assist in understanding case law for expert witnesses. There's 3 topics and an assessment. The first is sources of South African law. So we'll have a look at the sources. Then the importance of case law as a source of law regulating expert evidence, and the reading a judgment with the help of AI. And then there's an assessment for lesson 1. So this is your course materials will be found here, and you'll see when you get access to the course materials that there's a video component and then a text component as well. The text component you can go back to and have a look at. Sometimes it's nice to look at the text, but the video, I will give video explanations on each of these topics. There will be, well, most of them, one or two, there's not the need for a video, but ordinarily there will be a video as well as text for you to follow, and you can then work through that course material, which will be available on the website. And you will continue to have access to that course material even when the course is over. So the idea is that you can then go back and use it as a resource if you encounter those sorts of situations in practice. I will also take you through when we do the actual, as I do deal with each topic, I take you through, this is where you'll find the topic at the beginning of the video. It'll only take you 1 or 2 videos, and you'll be, I think, familiar with finding your way around the learner management software. But that will then be relevant to, in particular, the next few weeks as we move forward and you start engaging with the material. And then we will then culminate on the 24th and then on the 31st. And then there will be an assessment, which you will be given. Pass your assessment, by attending on the 24th and the 31st, you will get your CPD accreditation. You do not need to pass the assessment to get your CPD accreditation. So if all you want is your CPD points, that's all you're after, just attend, you'll get your CPD points. But if you're wanting an actual in-depth knowledge of what goes on with this, and you're really wanting to upskill yourself and empower yourselves and raise your levels of professionalism, then I think that it really does. And I talk from 30 years experience as an advocate. This starts getting right into the bones of what experts should be doing. And if you apply yourself diligently and then take that into your practice, a very, very good backdrop to then developing these skills and lifting your levels of professionalism and your reputation as practitioners. All right, so that is then an overview of the course. I thank you for your time. This has been recorded. Are we going to make this recording available? As I said, we will then also put you onto this information we put onto the Advanced Expert Witness Training WhatsApp group. If you are not on the WhatsApp group, or if you can't get access to the material, goes without saying, please reach out to me. We will sort you out. There is a lot of admin that goes on in the background, so please forgive us if there's the odd little glitch, especially this is the first time we're presenting this material. We work very hard to get on top of the technical stuff, but we're not technicians. We don't, our expertise lies elsewhere, but we have outside source providers, resource providers that can help us if it becomes technical, but it does take a lot of management as well. So work with us, we will get you there. And I'm very much looking forward to this course. I thoroughly enjoyed presenting the intermediate expert witness training course, and I am looking forward to this. There's some faces that I recognize, names that I recognize, and the standard of participant in the intermediate course was absolutely staggering. Those that watched the interviews with the participants, I'm sure will share that. So that's all I'm going to say now. I'm not going to take Q&As tonight because we're going to deal with that over the next few weeks. And I think some people are shy and they've got questions that we will deal with that over the next few weeks. That's why we've got the next few weeks, is to give that engagement. Any recommendations or suggestions, please be kind. We do our best to deliver a high quality product. We can't always get it right. If you've got suggestions, please just put in the format of a constructive suggestion and just keep it private if it's something a bit negative. If it's positive, don't make it private, make it public and let everybody know. All right, I will see you all on the course. If there are any further questions or queries or what have you over the next 2 days, and I would say by the end of this week, we will have everything. You will be properly onboarded and we will start going through the material. There will be material on the site already for you to work through. You can work through that at your own pace. That's the idea. And then we will take it forward from there. Thank you very much, Audrey. That's very kind of you. And have a good evening. And we will get stuck into this. I think it's going to be a really exciting and interesting course. Thanks, everybody.